welcome to the Deep Dive. Today, we are cracking open one of the really tough areas in criminal law, homicidal self-defense. The question we're tackling is pretty fundamental. When does that basic right to protect yourself, self-preservation, when does it cross the line? When does needing to kill become a criminal choice?
It's a razor-thin line, that's for sure, especially when the person claiming self-defense might have, had a hand in starting the whole thing. This dive is going to be rigorous because these legal ideas, they're layered. One decision really dictates if the next defense is even available. So we'll start with the basic idea, necessity, and then layer on two key limits: the aggressor doctrine and the duty to retreat. We'll use United States v. Peterson as our main example throughout.
Right, and the really striking thing here, which I think we'll show step by step, is how in Peterson, a seemingly minor argument over, windshield wipers? It ultimately meant the defendant lost the right to stand his ground, even in his own yard.
Exactly. And we need to unpack the court's logic, really dissect it, to see how someone forfeits such a fundamental concept.
Okay, so let's set the foundation first. If someone takes a life and claims self-defense, what's the core legal principle? What absolutely has to be proven for that claim to work?
The core idea is necessity. Simple as that, almost. The right to use deadly force, it only exists when that necessity begins, and it stops the second the necessity is gone. And for a defendant to be completely cleared, legally speaking, for a homicide based on self-defense, 5 specific things have to line up perfectly.
Okay, lay them out for us, and maybe highlight the one that often causes the most trouble.
Sure. First, there had to be a threat of deadly force against the person claiming defense. Could be real, could just reasonably appear real. Second, that threat has to be unlawful and immediate, like right now. Third, the defender must have honestly, truly believed they were about to die or suffer serious harm. Imminent peril. Fourth, their action using deadly force had to be necessary to save themselves.
Okay, those 4 make intuitive sense. What's the 5th, the tricky one?
The 5th one. That's the real hurdle. It's not enough that the defender honestly believed all this. Their beliefs also have to be objectively reasonable given everything that was happening.
Wait, hold on. So even if I genuinely believe, deep down, I'm about to be killed, if a jury looks back later and says, well, your fear wasn't objectively reasonable, I could still be found guilty.
That's exactly right. It's a huge point. Your personal subjective fear isn't enough by itself. The law demands objective validation. You can't shoot someone just because you unreasonably thought they were grabbing a gun when, anyone else would see they were just getting their keys.
Okay, that objective standard is critical. Now, let's complicate it. What happens if the person claiming necessity, the one who felt threatened, actually started the whole mess? Or maybe didn't start it, but ramped it up to a deadly level?
And that leads us straight into the aggressor doctrine. It's a major limitation. The law basically says the right to kill in self-defense. It's reserved for those who are free from fault in the difficulty. It's generally denied if you're the one who, incited the attack or encouraged the fight or otherwise kind of engineered the situation where killing became necessary.
So the core idea seems to be if you could have avoided the whole deadly encounter by just behaving differently earlier, then the killing wasn't truly necessary in the eyes of the law.
Precisely. You can't create your own necessity to kill and then claim self-defense. It just doesn't work that way.
The doctrine sounds straightforward, but United States v. Peterson really shows how complex figuring out who's at fault can be. Tell us exactly how this argument over car parts escalated so tragically.
Yeah, the start was almost, petty.
Let's analyze United States v. Peterson. First, walk us through the legally dispositive facts. What did the court focus on?
Okay, so Peterson was arguing with Kate, who ended up deceased. The argument was because Kate was taking windshield wipers off Peterson's old wrecked car in the alley. They yelled back and forth. But here's the key part. Witnesses said Kate then got back in his car, seemed like he was about to just drive away. The conflict looked like it was de-escalating. But Peterson, he goes inside his house, comes back out holding a pistol, actually stops to load it there in the yard, and then shouts at Keith something like, "If you move, I will shoot," daring him to come into the yard. It was only after that Keith got out of his car, grabbed a lug wrench, and started walking towards Peterson, and that's when Peterson shot him.
Okay. And based on those facts, what was the core legal issue specifically about Peterson being the aggressor?
The legal question boiled down to this. Did Peterson's actions, going to get the gun after the initial argument seemed over, loading it, issuing that deadly challenge, did that count as an affirmative, unlawful act of aggression? An act serious enough to cancel out his self-defense claim later, even though Keat did eventually advance with that lug wrench.
Got it. So what rule of law did the court use to decide this? Can you state the full rule and break down its testable parts, its elements?
Yeah, the court applied the basic rule. An aggressor can't claim self-defense. The specific black-letter rule they articulated was, an affirmative unlawful act reasonably calculated to produce an affray foreboding injurious or fatal consequences is an aggression which, unless renounced, nullifies the right of homicidal self-defense. So this rule really has two key elements we need to check.
And those elements are?
First, did the person commit an affirmative unlawful act that was reasonably likely to lead to a dangerous, potentially fatal fight? And second, if they did they effectively renounce that aggression before the killing happened?
Thank you. Now for the court's elemental analysis. Let's break it down element by element. How did the court apply that first element? Did Peterson commit an affirmative unlawful act reasonably calculated to produce an affray?
Okay, so element one, the unlawful act. The court looked at the timeline. Before Peterson got the gun, it was just yelling, maybe a minor property issue, not deadly. The court said Peterson's act of getting the pistol, loading it, and then issuing that explicit threat and dare that was the affirmative unlawful act. Why? Because that act was calculated to, and did, escalate a non-deadly argument into one that had a deadly cast, as the court put it. So yes, element one was met. He was the aggressor.
Understood. He changed the nature of the conflict. Now, what about the second element? Did Peterson successfully renounce his aggression?
Right, renunciation. The rule here is pretty clear. To get your right to self-defense back after being the aggressor, you have to communicate to the other person your intent to withdraw, and you have to actually try to withdraw in good faith. The court pointed out the evidence showed Keat was literally about to leave before Peterson came back armed. Peterson didn't withdraw. Instead, he doubled down, maintained the threat, issued the challenge. No attempt at withdrawal. So no, he absolutely did not renounce his aggression. Element two was not met.
And after analyzing both elements, he was the aggressor. And he didn't renounce. What was the court's final conclusion?
The court concluded the evidence was strong. The jury could easily find, and did find, that Peterson's actions fit the definition of aggression under the doctrine. Since he initiated the deadly phase and never backed down, his right to self-defense was gone, nullified. So the manslaughter conviction stood. The law essentially prioritized preventing self-generated violence over his claim of defense.
Okay, that clarifies the aggressor doctrine. But here's where it gets really interesting. Let's test this idea of renunciation with a hypothetical, make it really stick. Imagine someone starts a fight, maybe over property, pulls out a weapon, looks really aggressive. But then suddenly they get scared. They visibly toss the weapon, say 10 feet away, turn completely around and start running away. But the person they initially threatened pulls out their own gun and shoots the first person in the back as they're fleeing. Would the aggressor doctrine still prevent the first person or their estate from claiming self-defense was violated?
No, absolutely not in that scenario. The aggressor doctrine wouldn't bar the claim there. Why? Because the whole point of renunciation is about restoring necessity. By clearly, visibly disarming, throwing the weapon away, and fleeing, the original aggressor has unequivocally communicated withdrawal. They've broken off the attack. At that exact moment, the necessity for the other person to use force evaporates. Shooting a fleeing, disarmed person isn't defense, it's retaliation, it's gratuitous. So the original aggressor's fault is essentially purged by that clear renunciation. The right to not be attacked unnecessarily is restored.
That makes perfect sense. The renunciation has to be clear and unambiguous. Okay, let's move to the second big issue in Peterson, this duty to retreat. Now, Peterson was standing in his own yard, his property. You'd think that's his castle, right?
It's it.
He argued he shouldn't have had to move an inch. What's the general rule on retreating, and what exactly is this castle doctrine?
Right, so traditionally, the common law had this retreat to the wall rule. It basically meant if you could safely get away from a fight instead of using deadly force, you had a duty to do that. Now, many places in the U.S. today are stand-your-ground jurisdictions, no duty to retreat anywhere you're legally allowed to be. But the D.C. Circuit, where Peterson was decided, follows the older minority approach.
Okay, so in D.C., not retreating when you safely could,
Yeah,
that's something the jury can hold against you when deciding if your force was excessive.
exactly. It's a factor they weigh, unless the castle doctrine applies. That's the big exception. The idea is your home is your sanctuary. If you're attacked in your home, and sometimes this extends to the immediate area around it, the curtilage, like a yard, you generally have no duty to retreat before using deadly force.
Okay, but Peterson was in his yard. That sounds like curtilage. So why wasn't he automatically covered by the castle doctrine? Why did he potentially have a duty to retreat back into his house?
Ah, and this is the crucial intersection. This is where being the aggressor comes back to bite him. Again, the court had to decide if the castle's protection extends to someone who wasn't blameless in creating the danger in the first place.
All right, let's isolate this retreat question. Using our structured approach, what were the legally dispositive facts regarding Peterson's location and his actions, or lack thereof, regarding retreat?
Simple facts here. Peterson was in his yard when he shot Keat. Keat was advancing towards him with the lug wrench. Peterson did not try to retreat further back, like into his house, even though that might have been a safe option. And critically, the trial judge told the jury that if they found Peterson could have retreated safely but chose not to, that failure to retreat was a circumstance they could consider when deciding if shooting Keat was excessive force.
Got it. And the core legal issue on this point?
Can a defendant claim the absolute protection of the castle doctrine, the no duty to retreat rule, when that same defendant has already been found to be at fault, the aggressor, in starting the deadly phase of the conflict?
Makes sense. And what rule of law did the court apply to answer that specific castle doctrine question? What's the test?
The court relied on a well-settled principle. The special privilege of the castle doctrine, the right to stand your ground at home without retreating, can be invoked only by one who is without fault in bringing the conflict on. It's a shield for the innocent victim in their home, not the person who provoked the fight there.
Okay, so now for the court's elemental analysis on this rule, there's really just one key element to test here. Was Peterson without fault in bringing on the conflict?
Exactly, and the court tied this directly back to its earlier finding under the aggressor doctrine. Since they had already established that Peterson was the aggressor, he's the one who escalated it to deadly by getting the gun and issuing the threat. He simply was not without fault. He wasn't blameless. His actions in provoking the deadly encounter were significant enough, the court decided, to make him forfeit the special, absolute protection of the castle doctrine. You can't start the fire in your own house and then claim sanctuary from it.
So, after analyzing that element, he was not without fault. What was the court's final conclusion regarding the judge's instruction about retreat?
The court concluded that because Peterson had lost the benefit of the absolute no retreat rule by virtue of being the aggressor, the trial judge's instruction was perfectly correct, telling the jury that Peterson's failure to retreat, if they found he could have done so safely, was just one factor to consider in judging the excessiveness of the force used. That was the right way to handle it. He didn't get the automatic pass of the castle doctrine.
Wow. That really demonstrates how interconnected these doctrines are. Being labeled the aggressor at the start basically cascades down and strips away other potential defenses, even the sanctity of your own yard.
It absolutely does. And this brings us to a crucial point for anyone trying to analyze these problems, maybe for an exam or just to understand the law. You need a kind of mental checklist to navigate these nested issues. Based on what we've discussed today, particularly through Peterson, we can synthesize a diagnostic framework.
Okay, give us that actionable checklist. How should someone approach a self-defense scenario involving these issues?
All right, think of it in steps. 1. Start with necessity. Always begin here. Did the defender face an imminent threat? Was it objectively reasonable to fear death or serious harm? Was the force used actually necessary? If the answer to any of these is no, the defense likely fails right there. 2. Test the aggressor doctrine. Assuming necessity seems plausible, ask, was the defender at fault? Did they commit some unlawful act that was calculated to cause this deadly confrontation? 3. Check for restoration or renunciation. If you found they were the aggressor in step 2, did they clearly communicate and attempt a good faith withdrawal before the force was used? If yes, their right to self-defense might be restored, so proceed. If no, self-defense is barred, stop here. 4. Test the duty to retreat. Okay, assuming the defender was not the aggressor or successfully renounced, now check the jurisdiction's rule on retreat. If it's stand your ground, fine, but you still assess if the force was excessive. If it's a duty to retreat jurisdiction, like DC, did the defender fail to retreat when they safely could have? And finally, 5. Test the castle exception. If there was a duty to retreat from step 4, was the defender in their home or curtilage? If yes, ask the critical question with Son Peterson. Was the defendant without fault in starting the deadly conflict? If yes, they get the full castle doctrine protection, no duty to retreat. If no, like Peterson, then the castle doctrine's absolute protection is unavailable, and their failure to retreat just becomes another factor for the jury to weigh regarding excessive force.
That framework really highlights it. The without fault element is the linchpin, especially for that powerful castle doctrine defense. Being the aggressor is like a master key that locks you out of other protections.
It really is, and it forces us and you, the learner, to think about the underlying policy here. The law of self-defense is always trying to balance the right to live against the need to prevent unnecessary violence. It's looking backward, asking, could this death have been avoided?
Mm. So the final question for you to chew on is this. How much weight should the law give to limiting self-help and settling fights versus the right to defend yourself, especially when you're technically on your own property? Peterson suggests the law often prioritizes stopping the conflict, even at the cost of limiting defense on home turf if you help start the fire. That's the tightrope.